Hello and welcome to the New York Immigration Coalition's video series addressing COVID-19 disparities. My name is Kaya Groom. I am the Immigrant Services Support Events Associate at the NYIC, and today we will be discussing public charge, what it was, what it is, and what to do. Public charge is used in immigration law to describe a person who is primarily dependent on the government for support. Immigration officials review applications for visas and green cards to determine if a person is likely to become a public charge based on the individual's income, age, family size, health, education, job, and affidavit of support, which is a contract with a sponsor. What it was. The public charge immigration test has been part of U.S. immigration law since 1882, when it went into effect the same year as the Chinese Exclusion Act. On February 24, 2020, under the Trump administration, changes to the public charge rule went into effect. These changes expanded the services that qualified green card applicants to be deemed a public charge to include cash assistance, for example, supplemental security income, temporary assistance for needy families, safety net assistance, federally funded non emergency Medicaid, SNAP, and Section 8 and Section 9 housing program. On March 9, 2021, after a series of court cases, the Trump administration's public charge rule was struck down. Public charge returned to the definition from the 1999 Interim Field Guidance, which defines a public charge as someone who has become for deportation purposes or who is likely to become for admission/adjustment purposes primarily dependent on the government for subsistence. This means that as of March 9, 2021, it is safe to access health, food, and housing programs. These programs include SNAP, Section 8 and other housing programs, Medicaid, Child Health Plus, and Essential Plan, WIC, HEAP, Head Start, short-term emergency assistance, job training, transportation assistance, emergency disaster relief, unemployment insurance, pandemic relief payments, and much more. Accessing these benefits will not make you a public charge. Vaccines and public benefits specifically related to the COVID-19 pandemic, including COVID-19 testing, prevention, vaccination, and treatment, food assistance, housing programs, and certain health coverage, and more, are no longer considered a public charge. These benefit programs are safe to access regardless of your immigration status and will not affect your immigration application. If you have questions about scheduling a vaccine appointment, view our video on how to schedule an appointment at nyic.me/COVID-19 vaccine, or view the NYIC vaccine guide at nyic.me/COVID vaccine guide. To learn more about if a public benefit can put you at risk of being a public charge, take the public charge test at keepyourbenefits.org/en/na/use-the-guide. This guide is safe and secure. Under the current public charge rule, USCIS considers a person's past, current, or future receipt of public cash assistance for income maintenance to be a public charge. The use of supplemental security income, cash assistance under the Temporary Assistance for Needy Families program, state and local cash assistance programs that provide benefits for income maintenance, often called general assistance programs, and receiving long-term institutional care, for example, being in a nursing home or mental health institution at government expense, can determine you to be a public charge and affect your application for status. In addition to public benefits used, the public charge test also considers income, employment, education, health, family status, and affidavits of support to determine if someone will become a public charge. The public charge rule applies to applicants seeking admission or adjustment of status, including immigrants applying for lawful permanent residence, green cards, through a family-based petition, and lawful permanent residents who leave the U.S. for more than 6 months and then seek to re-enter the U.S. A slightly different rule applies to some non-immigrants applying to change or extend their visas, for example, student visas. There is no public charge test for asylees, refugees, URT visa applicants and holders, human trafficking victims of crimes, VAWA self-petitioners, people seeking or granted special immigrant juvenile status, U.S. citizenship, green card renewal, asylum, DACA, TPS or DED initial applications and renewals. What to do? All New Yorkers, regardless of immigration status, have a right to access benefits including SNAP, Section 8 and other housing programs, Medicaid, Child Health Plus Essential Plan, WIC, HEAP, Head Start, short-term emergency assistance, job training, transportation assistance, emergency disaster relief, unemployment insurance, pandemic relief payments, and much more. If you are unsure if using a public program you are eligible for will make you a public charge, you should speak with an immigration lawyer. If you need to speak with an immigration lawyer, please visit Action NYC at access.nyc.gov/programs/Action NYC or call the Office of New Americans hotline at 1-800-566-7636. Thank you for tuning in. If you have any questions regarding public charge, please visit the resources provided throughout this video and linked in the description. Please email events@nyic.org with any questions, and to stay involved with the New York Immigration Coalition, follow us on Facebook, Instagram, Twitter, and YouTube. Stay safe and take care.